So good morning and welcome. My name is Roy Dennis from LUPC. I'm a Senior Category Manager for Professional Services. This is a UK UPC call, so should be only UK UPC members on the call. It's part of a webinar series, and today's webinar series is the post-pandemic employment issues. Really pleased to have James Rhodes from DAC Beechcroft here today. DAC Beechcroft are a specialist law firm, and they're available to our members, excluding APUC, on HR, employment and employment disputes lot. APUC members may be able to interact with the DAC Beechcroft, but you're not named on the framework. I do appreciate there are a number of people on the call today from a non-procurement background. It is a HR sort of subject that we have today. And if you have any questions with regards to frameworks and the procurement side, please feel free to reach out for me and I'll be able to help you work your way through any framework questions that you have in terms of interacting with James at DAC Beechcroft. Okay, we are in webinar mode, which means that your cameras and microphones are off at this time. And if you have any questions that you would like to raise, please put them in the Q&A button. Put the details through there. If you see somebody else put a question in there for James, do a thumbs up if it's something that you would also like to ask. It will increase the likelihood of that question being asked, as it will go to the top. And please do engage, and there will be room for Q&A as we go along. So with that note, I will pass you across to James.
Thank you, Roy. Good morning, everybody. Thank you for taking the time out this morning to join us. You're very welcome. Just a couple of housekeeping points. I just noticed somebody's put in the chat that they can't currently hear anything. I hope that's just an isolated issue for that one participant, and that everybody else can hear okay, that nobody else has yes, so we have confirmation somebody else can hear. So hopefully that issue will be sorted and everybody can see and hear us okay. So thank you. Yes, I'm James Rhodes from DAC Beechcroft. I'm an employment law partner. Just one housekeeping point before we start, which is that I'm in the office and we are expecting a fire alarm test at some point this morning. So apologies if that goes off in the background. It should just be a test and will go off after, it'll stop after 10 seconds or so, but apologies if that causes any slight disruption. So on with the show, so to speak. Just pausing on the title, just before we get into the detail. Post-pandemic employment issues. It struck me preparing for this morning that perhaps that's a slightly optimistic title to talk about post-pandemic. I think I did quickly look this up. I think we are, strictly speaking, still in a pandemic. And COVID obviously hasn't gone away. We are obviously much more used to dealing with it, and it's not as disruptive, as it has been. But it is still there. It's bubbling away in the background. There's always a possibility, hopefully not, possibility it might come back with a vengeance. And then, just as if that wasn't bad enough, I know there's some concern in certain circles that bird flu could become the next pandemic. So we might be mid, pre or post pandemic. Who knows? But so obviously there's a COVID theme to this talk this morning. But the sort of principles that we're going to talk about would be equally applicable if, God forbid, there is a bird flu pandemic and that becomes as problematic as COVID. So the same sort of principles will apply. So that's just a little preface to that. And then in true government, yes, optimism. Yeah, yes, thank you, Nicola. Yes, my optimism. Yeah, my glass is always half empty. So, but hopefully that's it's going to be fine. It will be fine. So in true government COVID briefing style, next slide, please. There we go. So we are just a quick overview of what we're going to cover today. We're starting with safe workplaces, duties, health and safety duties living with COVID in the workplace. We're going to spend a bit of time talking about reluctant returners to the workplace, and the sort of reasons why people might be reluctant to commit to coming back fully into the workplace for various reasons, and how you might address those as HR professionals. And then we're going to look at COVID, long COVID as a possible disability, and managing those with long COVID. So that's just a quick overview. Do feel free to pop questions in the chat as we go. I'll try and keep an eye on that on the chat box. I think there's a way that you can promote a question. So if somebody else asks a question that you like, you can give it a thumbs up, and that will bump it up to the top of the queue. So feel free. Right, next slide, please. Yeah, so starting with safe workplaces, and next slide, please. Okay, so we're going to just start with the legal framework around health and safety, and it all goes back to the 1974 Health and Safety at Work Act, which still is the sort of the predominant legislation relating to health and safety. That the general duty to protect employees is at section 2. And you can see there that it's employers have a duty to ensure, so far as is reasonably practicable, the health, safety and welfare at work of all employees. Employees in the wide definition, wide sense of the term, so that would include workers, agency workers, bank staff, etc. It's so it's the widest possible definition of employees. It's covered there. Section 3, and this is just worth bearing in mind when we look at some of the scenarios a little bit later on. The duty extends not just to employees, but also to people who are not employed by the organisation, but who may be affected by what the organisation does, and you have a duty not to expose those people to health and safety risks. So that would include, I know a lot of you from higher education institutes, so that would include students, visitors, but it would also include, particularly where we're concerned with, for example, if members of staff live with somebody who, for example, is clinically extremely vulnerable, you may have to have regard to the domestic circumstances of your staff, and then we'll put some flesh onto that particular bone as we go through this talk. So those are the general duties under the Act, and then the 1999 regulations. Oblige employers to carry out suitable and sufficient health and safety risk assessments relating to the exposure to risks of both employees and, again, non-employees, as I say, relevant to what we're going to talk about later. Breach of those duties can lead to enforcement action. It's the health and safety exec that is primarily responsible for ensuring compliance and for prosecuting those organisations and individuals who have breached those duties. It's also just worth remembering that we're talking about risks not just to physical health and safety, but also mental well-being. The duty to make risk assessments applies both in the workplace and also to those who are working from home. So, for example, people who have set up office space at home using their own equipment, you have an obligation to do display screen, display, what's it called? Checking that the screens are all
DSE.
right. DSE, that's it. I couldn't remember what it stood for. DSE, mine had gone black. DSE assessments, making sure that that they have a proper chair, that their posture is fine, but also in the context of mental well-being, the dangers of potential lone working, the impact on stress of people who are not working in the office in a surrounded by peers and having that support network. So that risk assessment is not just confined to the workplace, it's also, you have to have regard to risks of people who are working at home, doing work for you. So that's just the basic legal framework. We're going to just drill down a little bit further into some more detail. So if we can just move on, please, Roy, to the next slide. So what does the duty mean? Well, you have an obligation to implement whatever measures are reasonably necessary in the light of your own particular health and safety risk profile. To mitigate those risks, there are still, although there are no COVID restrictions anymore, there are still guidelines issued by the government, the NHS, the Health and Safety Executive, for example, relating to managing COVID in the workplace. So have regard to the guidance as it is from time to time. And I should just, I suppose, just date stamp this for those who might be watching the recording. We're recording this on the 9th of February 2023, and so that this is the law as it currently stands today. And obviously we know from the last couple of years that the situation can change quite quickly. So I just date stamp it for those who are watching the recording. So I'm not going to dwell too long on this, because all your organizations will have their COVID risk assessments in place. You'll have all your risk assessments. Hopefully you've engaged with employees, you've publicized your risk assessments, and that you're flexible with how you implement those. I think at the very least, I'm sure pretty much every organization will still have a requirement that if somebody is exhibiting COVID symptoms or has tested positive, that they must stay away from the workplace to prevent potential exposure to others. So at the very least, most organizations will be doing that, but you may still have other particular measures in place depending upon your particular risk profile. And hopefully you have gone through the process previously of identifying potentially high-risk employees and conducting personal risk assessments if there are people who are, for whatever reason, particularly vulnerable, either because they themselves have an underlying health condition or that they live with somebody who may be vulnerable. Okay, so
James,
moving on, please. Yes.
Can I just ask you a quick question?
Of course.
This is me personally asking a question.
Yeah.
Now. So in the event that an employer has a employee that reports in that they I'm never too sure these days that in terms of testing and so on is that they identify that they have COVID. I believe that there are guidelines to say that you should try to isolate and and minimize exposure. From the other side, from an employer's side, their duty of care is that they perhaps shouldn't force them into work or force them to do things beyond what would be reasonable for anyone that reports for any illness, I suppose.
Yeah, absolutely. I mean, particularly in the light of of an infectious illness, that you should be taking positive steps to make sure that person stays away from the workplace, or at the very least, if they're coming in, that there are measures in place to mitigate the risk of that infection spreading to others. Because if somebody acquires a workplace infection, that as a result of the employer's failure to implement infection control measures, then that is could potentially be a breach of the employer's duty. So that's why I say most organizations will still have in place obligations on employees to report if they have symptoms or have tested positive, and to stay away as a consequence.
Okay. I shall do the next slide.
Okay, thank you. Yeah, so just again, we're getting into a bit more detail here. We're going to look at a couple of cases shortly about employees who have, particularly during when the pandemic really was raging, refusing to come into work because of the risk to their health. And there are various statutory protections for somebody an employee who takes steps to protect themselves or others in circumstances where they have a reasonable belief that they are in serious and imminent danger. And those protections include the right not to be dismissed on such grounds. That's one of those categories of dismissals which are automatically unfair and don't require any qualifying 2-year service to acquire that right. Not to be subjected to a detriment, and as we'll see when we look at a couple of cases in a minute, the issue is whether the employee reasonably and genuinely believes that they are in serious and imminent danger from the workplace. And that also extends to circumstances where they have a reasonable belief that somebody that they live with might be in imminent or serious danger because the employer has failed to make the workplace safe. So yes, if we move on, we'll look at this in a bit more detail, please, Roy. Next slide. So yeah, a couple of cases on this. Court of Appeal case in Rogers and Leeds laser cutting, which some of you may well have seen reported in the HR press recently, because it's quite a recent decision. It's a good decision because it's Court of Appeal, so it carries a lot of weight, and also that the courts have done a good job in sort of explaining the circumstances in which this type of protection can arise, and where the statutory prisons can be breached. So this case concerned a Mr. Rogers, who worked for Leeds Laser Cutting. Going right back to the start of the pandemic, he told his employer that he wasn't going to come into work until lockdown eased. Obviously, at that point, if you recall, we had no idea how long this was going to last. I think we maybe thought it was just going to be 2 or 3 weeks, but as we know, it didn't. But he said, I'm not coming back until lockdown eases. His concern was for his vulnerable children. I think from memory, he had a fairly newborn baby, and he also had a child with an underlying health condition, and he was worried about the risk of coming into work and picking up an infection and then bringing it home to his vulnerable children. He issued what's described as a self-isolation certificate. I can't quite remember what the back then what all that was about, but he self-certified anyway that he was going to be self-isolating for the period from the 28th of March to the 3rd of April 2020. So this is very early on in the pandemic. I think it was the 23rd of March that Boris Johnson told everybody to stay at home. So this is so very early days. So he self-isolated for a week or so, but thereafter he failed to make any further contact with his employer, and he was dismissed on the 26th of April for being AWOL. He brought a claim that his dismissal was automatically unfair under Section 100 of the Employment Rights Act 96. So that because he said that he was dismissed because he took reasonable steps to avert what he reasonably believed was a serious and imminent danger to his vulnerable children presented by traveling to a potentially unsafe workplace. Ultimately, he lost the case, and a number of reasons for it. First of all was that the employer had implemented and was following all the relevant government guidance as it stood at that time, which I think, thinking back, I think we were still in the realms of wash your hands while singing happy birthday and stay 2 meters apart. So this was pre-masks, but anyway, they were following all relevant guidance. So they were, on the face of it, insofar as you could be in those days, a COVID safe employer. So it wasn't reasonable for him to believe that that there was a serious and imminent danger from their working practices. But crucially for him, it was found that he didn't reasonably believe he couldn't reasonably believe that he was in serious imminent danger, or his children were in serious imminent danger, because there was evidence that during this period where he was supposedly self-isolating from work, he had driven a friend to hospital in circumstances where it was at least as risky, if not more risky, of getting an infection from driving a friend than it would have been to coming into work. So if he was that, in other words, if he was that worried about COVID, he wouldn't have driven his friend to hospital during that period where he was refusing to come into work. And then not long after his dismissal, when things started to ease up, I think over that summer, he got a job in a pub, which was much more likely to be a more dangerous environment than the environment that he'd refused to come into. So it was found that he didn't reasonably believe that the workplace presented a particular risk that was any higher than the risks he was prepared to run in his private life by driving his friend to hospital or working in a pub, etc. So ultimately he lost his case. And then if we move on to the next slide, please, Roy.
Before we do that,
yes,
James,
yes.
In the chat, Alice has asked a question as to, are there any rules around paying for COVID isolations now, or proof of COVID if employees are not able to work from home, potentially if they're having 5 days off, and especially where they're not that unwell with it?
From a statutory point of view, no, I don't think there are any particular rules. This just, most of this now, the onus is put really on employers, what they want to do with somebody in those circumstances. What certification do they require? What sick pay arrangements do the employers have? And this is sort of, I think, one of the criticisms of the way in which we've moved from the government sort of putting measures in place, furlough schemes, sick pay, etc., to putting the onus back on employers to do the risk assessments and to implement whatever sick pay arrangements are in place. So
really now I suppose it's very similar to any other illness.
Yeah.
So if you had a flu or a cold sort of thing, and you're an employee that rings in and says you've got a flu or cold, the only difference is that with the COVID, there's still that guidance of isolating for 5 days, I believe.
Yeah, that's right. Yeah, it's tricky because, you know, and particularly with testing, I'm not even sure now how easy it is to get home testing kits, for example. So there's a real question mark over, you know, if you've got a cough or a temperature, can you actually test whether you're COVID or not, or whether now employers are saying, well, just if you're exhibiting the symptoms, don't come in or work from home until you're asymptomatic. So I think that is one of the problems of the current regime, is that there's a lot of the onus is put on employers now to manage these kind of issues, and what certification, etc., do they require.
Okay, so I hope that answers the question, Alice.
Thank you. Yeah, so just on a similar theme, this is the other side of the coin. This is where the employee won in this the sort of claim that Mr. Rogers failed in. So this is Mr. Gibson, worked as a chef at Lothian Leisure in a restaurant. So going back to summer 2020, I think it was, from memory, I think it was around about the 12th of May that restaurants were allowed to reopen, albeit that they, I think, possibly limited to garden service only. Again, I can't quite remember the exact circumstances we're in, but whatever it was, when the restaurant reopened, he was concerned about the implications of coming back into work, because his father, who he lived with, clinically vulnerable, voiced his concerns to the restaurant. The restaurant, unlike laser cutting in the previous slide, was not a particularly COVID safe workplace. So his concerns were perhaps much more well-founded than Mr. Rogers might have been. And also their response to it didn't do them any favors. He was told to just shut up and get on with it. and then sacked without notice. I think justice is done in this particular case. It was found that he did have a reasonable belief that there was a serious and imminent workplace danger, and that was a danger to his father, not to himself, but that, as we've seen from earlier slides, the duty extends to those who might be affected by employment. So he had a reasonable belief in a serious and imminent workplace danger, and he had been dismissed for voicing those concerns, therefore automatically unfairly dismissed. So that's, you see, that's the other side of the coin. So moving on, Roy, please. So I suppose on a similar theme, similar to a sort of another sort of subspecies of the voicing health and safety concerns under Section 100, there is, of course, the whistleblowing, dismissal and detriment that we're more familiar with, and it would be very easy to envisage circumstances in which somebody can make a protected disclosure about health and safety concerns relating to COVID, and they obviously have the right not to be dismissed or subjected to a detriment as a result. And I suspect that that Mr. Gibson in the previous slide could also have won his case on a whistleblowing basis. You know, if he'd made an if he'd raised concerns that the restaurant was failing in its legal obligation to protect his and his father's health and safety, then that is likely to have been a protected disclosure. So he could potentially also have won his case on that ground as well. Okay, so next slide, please, Roy. Disability discrimination. We'll look at this a little bit more detail as we come on to look at long COVID. You'll be familiar with the concepts: duty to make reasonable adjustments. Now that, just pausing there, that duty only arises in respect of adjustments in respect of a worker who has a disability. There is no duty to make reasonable adjustments because, for example, a non-disabled worker lives with somebody who has a disability. You don't have a duty to make adjustments to accommodate the disability of somebody other than the worker. However, a worker has a right not to suffer a detriment as a result of an association with a disabled person. So we'll look at that again shortly, and also the right not to be harassed related to either the worker's own disability or the disability of another person, for example, a family member. You know, I've had a case recently where the employee is alleging that they needed to take some time off to care for a disabled parent, and the employee alleges that the manager was giving them a hard time. Oh, you taking more time off again? Oh, this is, you know, you can't. This is, you're never at work, and blah, blah, blah. And that the allegation there is that is harassment related to the parent's disability. So that's how you can bring that sort of claim. So I'm going to say we'll look at those a bit more detail. So I won't dwell on this slide for the moment. So if we can move on to the next one, then please. So yeah, so we're just going to move on to reluctant returners, and just a few scenarios that perhaps all familiar with that we'll look at. So if we can just move on to those, Roy, and in each case, you've got to consider the reason why the employee is reluctant to return. What are the risks, and you've got to take reasonable steps to mitigate against those risks. So if we just look at the 4 scenarios on the next slide, oh, just go back one, Roy. We've just skipped one. There we go. So yeah, 4 scenarios we're going to look at. Each scenario gets slightly further and further removed from COVID. So the risks differ and sort of get slightly less as we move through each scenario. So looking at scenario 1 then, please, Roy, this is where the employee themselves has an underlying health condition, too worried to come to the office. And so if we just move on to the next slide, we'll just look at that. So so this is there's potentially two issues here. Somebody might have a health condition which means that they are particularly vulnerable to being exposed to COVID, and that COVID exposure could represent a very serious risk to their health. They might be immunosuppressed. They might have they might be undergoing cancer treatment. They might not have been able to be vaccinated because of the particular health scenario that they have. So there are some genuine clinical concerns arising out of the risk of getting COVID. But also, I suppose, there's a scenario where really the concern arises out of anxiety as a potential disability. So it's not necessarily that they have that they are necessarily clinically vulnerable, but they might be so anxious about the possibility of being infected that anxiety could potentially amount to disability, or the more difficult for them to establish that. So, in those circumstances, you have a duty, as we've seen from the earlier slides, to conduct a risk assessment for somebody, personal risk assessment for somebody in a high risk category. You're likely to need a medical or OH input. It's likely to be dealing with a disability. In that scenario, then the duty to make reasonable adjustments is likely to kick in. Is working from home an adjustment that you should make? And that going back to years previously, pre-pandemic, working from home was much less common. And going back certainly earlier days in my career, there was almost a certain stigma attached to working from home. People aren't really pulling their weight if they're working from home. All those perceptions, I think, have changed. Then we've proved to ourselves over the last 3 years that work can productively be done from home, that we have the technology to allow that to happen. So obviously you now have to approach working from home requests with a much more open mind than perhaps we would have done in years gone by. But still, there might be jobs where it's just simply not a viable option. If you're an academic who is doing a lot of lab-based research, they're going to have to be in the lab. They can't take the lab home with them. So that it might not be a reasonable adjustment to make, but there might be stuff you can do around the edges. You might say, well, you're going to have to come into the lab, but we can do things with the lab. We can increase the ventilation. We can socially distance you in the laboratory. And when you don't need to be in the lab, you can go work from home. So if you're writing up results, you're writing a report, making funding applications, all of that sort of stuff you could do from home. So you don't have to come in as frequently. So even where you have a heavily workplace-based job, there may be adjustments around the edges that you can do. And if they have to be wholly based in the workplace, then what additional measures might you be able to adopt to protect that particular person? Do you, for example, require anybody who's working in the same room as them to wear a mask? Is there a way that you can increase the ventilation in the room, social distancing, etc.? So you'd have to consider the risks and consider what steps you can reasonably take to mitigate those risks. So that's the first scenario. If we move on to the second one, Roy, and this is the sort of scenario we've looked at in both the Rogers and the Gibson cases, where somebody that they themselves isn't vulnerable, but they are concerned about the risks to somebody that they live with who is clinically vulnerable. And Roy, if we can move to the next slide, we've seen that the duty to make reasonable adjustments doesn't extend to making adjustments in respect of somebody else's disability. However, there is, as we looked at, there's the potential for subjecting somebody to a detriment because of their association with somebody who is disabled. So the sort of scenario I talked about, are you wanting more time off again to go and look after your father, whatever, that's potential harassment. It could be subjecting somebody to a detriment. You still, though, even though you don't have a duty to make reasonable adjustments, you still have a duty to consider the risks posed to people who are affected by your organization's activities. So that would extend to assessing the risk that the person who has the vulnerable parent or partner, whatever it is, might bring an infection back to that person. So what steps might you reasonably be able to take to mitigate against the risk of that person acquiring an infection in the workplace? So similar to scenario one, can they work from home? What additional measures can you make to the workplace to make their working environment even safer from the risk of infection? So again, you're going to have to do a risk assessment and consider what changes you can make. So moving on to scenario three, say we're getting slightly further away now from COVID itself. So this is a maternity returner, actually doesn't want to now return to the workplace as previously. They'd like the flexibility of working from home. They don't want to come back. They want to work from home. And then we are into perhaps familiar territory with flexible working requests by maternity returners. There will be an assumed indirect discrimination risk. Childcare is still disproportionately undertaken by women who are required to work full-time or to work wholly in the workplace. Women with children may be subjected to a detriment. Maybe it's more difficult for them to comply with the requirement to work full-time in the office. So again, consider, well, can we make a more flexible arrangement for this person? And because, as I said earlier, because we've now proved to ourselves that working from home can be effective, it's going to be more difficult for you to simply say, no, you've got to come back to the office. Well, why? What specifically? Why specifically do they have to be doing the job in the workplace? How much of it can be done at home? So you're moving away from a sort of disability, health and safety type of risk to indirect sex discrimination risk, which so it may be harder to justify a refusal to allow working from home, given the experience that we've had of working from home during the pandemic. And then final scenario, Roy, this scenario assumes that we're dealing with a pure lifestyle choice. Somebody who has thought, well, this is great, I can work from home, I could just go live anywhere in the country, I can now buy that dream cottage in the Yorkshire Dales that I've always wanted and just go and just never come back to work. I like this, thank you very much. I don't have to work in a laboratory or whatever. I don't need to come in, I could work wherever I want. So you're dealing with a pure lifestyle issue here. And this then, I think, rather than a legal issue, becomes more of almost like a retention issue, a recruitment and retention issue. Do you want to be, because you want to be attractive to new recruits and to existing employees, do you want to promote a culture where actually, yeah, you know what, we don't care, work where you like, we want to make your working life balance out with your home life, and if that means you're working from the Yorkshire Dales, that's fine, because a happy person is a happy employee. It's a recruitment and retention issue, and I know a lot of employers during the pandemic made a virtue of remote working as a recruitment tool, to attract the widest possible talent. Well, we no longer are looking within a pool of candidates who have to be within commuting distance of the workplace. We can cast our net more widely, and we can recruit people from all over. And you might decide, well, actually, we want to be seen to promote that, and so yeah, we're going to support somebody who wants to do that. But equally, you might decide, well, no, hang on, we think it's important from a culture, a team ethos perspective, that there should be some office presence, that it fosters good team relationships, a good culture, a good supportive environment, that people at least spend some time in the office all together, so that they feel that they're part of a team. and that therefore you're not going to support somebody to just decide that they're going to up sticks and never set foot in the place again. And then there are various things you can do. What does the contract say? Contract is likely, particularly somebody who was employed pre-pandemic, contract is likely to specify a particular place of a particular geographical location as the place of work. You might decide you're going to start getting heavy with this individual and saying, well, no, your contract says you've got to be based at this particular site. So you'll have to put your Yorkshire Dales cottage on the market and come back. Otherwise, we're going to dismiss you. So it kind of depends on what you. Yeah, sorry, Roy.
Alice has put an interesting
go
item
on.
in the chat, which was what if those staff received a London allowance but no longer came to London or no longer live in London?
Yes, well, yes. I mean, that's a very good point, and I think that increasingly there are likely to be conversations to be had around that. About, well, okay, fine, we're quite happy to support your dream lifestyle in the Yorkshire Dales, but you're not getting your London allowance anymore. And that obviously that will largely depend on the contract. If it's really, really well drawn, it will say you're only going to receive that London allowance for so long as you're based in London. And if their workplace base has changed, then you say, well, you're no longer entitled to that allowance. So yes, that is a conversation that increasingly employers are having. But on the flip side of that, I know that a lot of businesses have used the fact that, well, we'll still pay you London wages, to recruit people who are based in London. Look, we pay London wages, but you don't have to live in London anymore. So then that's been as a recruitment tool. Actually, we'll make it very attractive to people to come and work for us by still offering the London package, but not actually requiring people to work in London. And I think certainly in my industry, in the legal industry, that has been something that has been done to attract people to come and work for London firms without actually requiring them to work in London. I suspect that's not sustainable in the long term. And my view is that there will ultimately be, there will be a bit more of a leveling of the playing field, which is that maybe working in London won't necessarily attract the same sort of premium that it has done in the past, because not as many people are actually living and working in London.
Would equal treatment be a factor in this, though? That if you're doing it for one person, then you have to do it for all people. Yeah,
and ultimately you could end up in a scenario. You could end up with potential equal pay issues. That you've got let's say this person in my scenario is a man who previously worked in London, got a London waiting, then moved to his house in the Yorkshire Dales, continues to receive his London waiting, works in the same role as a woman who doesn't live in London, doesn't attract the London allowance, is doing the same job but for less pay. And she's, well, hang on a minute, I'm doing the same work as this chap in the Yorkshire Dales and he's getting paid a whole load more than me. What's your defense to that? Well, it's going to be more difficult to defend that, because you say, well, the reason he's paid more is because he gets a London allowance, but that doesn't really hold up much water, because, well, he doesn't live in London anymore. Why is he still getting a London allowance? So it does become problematic, and that there are going to be some challenges around London waiting, for example, and in this type of scenario. And that might be why you decide to say, have a conversation. Well, actually, your contract says you're based in London, so you've got a choice here. You can get yourself back to London, get your London waiting, or we're happy to accommodate your request, but you're not getting London waiting anymore. So which is it to be? And then you have a conversation, and the price he pays for his being allowed to work in the Yorkshire Dales is that he gives up his London waiting, and you agree to change his contract to change his base. I mean, that's potentially one way around that. So we'll move on. I'm just conscious of time, actually, because we've got a bit to go through. So long COVID, just to finish. So, and here we're drawing a distinction between the COVID, the test positive, you've got a bad cough, high temperature, feel terrible for a week, but then you're fine. Here we're talking about long COVID cases, which can affect someone's ability to carry out full range of duties or cause long or short-term sickness absences. And it can also be one of those conditions that flares up, dies away, flares up, fluctuating, recurrent condition. Somebody could be fine one day, but terrible another one. And so there's a pattern of working that's unpredictable. So just looking at that in more detail, Roy, if we just move on. So is long COVID a disability? Well, just to remind you all of the definition, which I'm sure most of you will be familiar with. Is there a physical or mental impairment? Does it have an adverse effect on normal day-to-day activities, which is substantial and long-term, which means has it lasted or is likely to last for more than 12 months? And that can include recurring and relapsing conditions. And also you ignore the effect of medication. So if somebody is fine because they're taking medication, in considering whether something is a disability, you consider, well, what would that person be like if they didn't take their medicine? Would it be a disability then? So just applying that to long COVID, Roy, if we move on to the next one. So most common symptoms, and I've taken this from the NHS website, extreme tiredness, shortness of breath, loss of smell, muscle aches, but also can include impaired memory, chest pain, insomnia, heart palpitations, dizziness, depression, tinnitus, sickness, fever, rashes, etc. So you can see actually that really any combination of those symptoms which last or are likely to last for more than 12 months could have an adverse effect on somebody's ability to carry out normal day-to-day activities. So we are potentially in the realms of long COVID as a disability, and we're just going to finish with a couple of cases where this has been considered. So the first one, Mr. Burke against Turning Point, Scotland. So Mr. Burke, a 20 years service, he got COVID, had very mild symptoms in November 2020. So his actual COVID infection was mild, didn't have too much of an impact, but he then went on to develop long COVID symptoms, and he had a lot of time off work as a consequence, and over a period of several months, occupational health advice was taken. There were exacerbation of symptoms, and although there was no significant medical concern, it wasn't life-threatening or limiting as such. When he had an episode, it was having a detrimental, adverse effect on his ability to do normal activities, and he ultimately went off for 9 months, at which point there was no foreseeable return date, and no adjustments likely to assist his return. And perhaps unsurprisingly, it was found that was a disability, because at the time of his dismissal in August 2021, although his long COVID had lasted for less than 12 months, the prognosis was that it was likely to last for longer than 12 months. So at the time of his dismissal, it was a disability because it was having the adverse effect, and it was likely to be a long-term condition, i.e. one that was likely to last for more than 12 months, and it was likely to be a recurrent issue. So long COVID was a disability in Mr. Burke's case, and then that contrasts, however, with the next case on the next slide, please, Roy. So this is Mrs. Quinn. She had COVID, off for 2.5 weeks with COVID, and then dismissed. 6 weeks later, after her dismissal, she was diagnosed with long COVID. However, in her case, it was found that it was not a disability, because when making this determination, a tribunal has to look at what was known at the relevant time. So what was the position as at the date of her dismissal? She obviously had only been ill for 2.5 weeks, so it hadn't lasted for anything like a long term at that point. Given that the overwhelming majority of cases of COVID resolved themselves within a short period, and only a small, tiny minority of people go on to suffer with long COVID, nobody could reasonably have anticipated that after 2.5 weeks illness, she would go on to develop a long-term COVID condition. So as at the date of her dismissal, her condition hadn't lasted for 12 months, and it wasn't likely at that point to last for 12 months. The fact that it then transpired that she did have it for more than 12 months was not relevant to the question of how likely was it at the time of her dismissal, and it was found it was unlikely, because from a purely statistical point of view, very unlikely that someone who's been ill for 2.5 weeks would then go on to develop a long-term condition. So it couldn't be inferred that she was likely to develop long COVID. So in her case, long COVID wasn't a disability. So you can see, it's purely fact specific, and it's all determinative about the timing that you're dealing with it. I mean, I think now, if somebody does move from the acute COVID infection to a more long-lasting impact, and that it's more likely that they have got long COVID at that point, the medical evidence suggests, well, if they have got it, then it may well be a long-term condition. You may be in Mr. Burke sort of scenario rather than a Mrs. Quinn scenario. So just, I think, final slide, Roy. So how do you manage long COVID? Well, basically, as you would any other underlying health condition, which is having either a short-term or long-term absence impact. Follow your normal process. But with whatever adjustments you think are necessary, should you adjust triggers? What about self-certification? Are you going to need OH advice? What adjustments could reasonably be made to assist that person? Again, working from home, would that make a difference? What impact is somebody's short or long-term absence having on the organization? Did that justify potential termination of employment if that was particularly disruptive with no prospect of it improving? Is there any job that somebody could be redeployed into where the effects of the long COVID would be less pronounced? And only in a very last resort would you consider dismissing someone. So I think, Roy, that is it. 5 to 11. Any other questions that we haven't covered?
There's no questions there at the moment. If you do have any questions, we do have 5 minutes, and put them in the chat. Whilst people are thinking of any questions that they may have, another one from me, and James is not expecting these questions, to have a quick slurp. It's just one more question from me, actually. In the middle there was a case of unfair dismissal. What's the likely remedy of that type of unfair dismissal?
Yeah, well, I mean, in a health and safety case, well, let's just go back to unfair dismissal principles. You get, and I've now got a terrible cough, which is just ironic, of course, given what we've just been talking about. I've just been talking for too long. I've just myself got. So you get a basic award, which in a normal unfair dismissal case is calculated as if you've a statutory redundancy payment, so based on years service and age, excuse me, and weekly pay. In a health and safety case, however, you get a minimum or a statutorily prescribed basic award. I think at the moment it's up to about £6,000, so potentially large basic award, and then loss of earnings as compensation. That could potentially be significant, particularly where somebody is in a position where it's not easy to get a job because either they are clinically vulnerable or living with somebody who is clinically vulnerable. So potentially quite an expensive claim in those circumstances.
Okay, thank you. There's no further questions that have come up in the chat. There's a few people that have ducked off on the call and passed on their thanks. What I will do is we'll make arrangements for the recording to be made available to those that registered for the event. I'll make sure that I'll get the information in terms of the contact points for the AC Beechcroft. I'll speak to you, James, and I'll make sure I get all the right details for those, and I'll send all of those out. If you have any questions with regards to accessing services with DAC Beechcroft through the framework, either speak to me directly. Quite happy to take any questions that you have directly. I've been mailing out the invites with my email address, but you'll have that when I send out the final email with the slide and the extra information. So I do hope that you enjoyed the webinar today. Thank you very much indeed, James, for your
You're welcome.
on this.
Thanks for having me.
And I shall stop the recording there and enjoy the rest of your day.
Okay, thank you.